713225190. How our attorneys will determine the cause of your Houston truck accidents. Commercial trucks accidents often require extensive investigation and fact-finding to determine fault in an incident and build a case with corroborating evidence. When investigating a potential personal injury claim, a Houston 18-wheeler accident lawyer from our firm will look at various documents to see if the driver or trucking company cut corners or did not adhere to important safety regulations, including employment records, certifications of the driver, trucking logs, inspection records, maintenance records, citations for past driving violations. While investigating your truck accidents, we search for vehicles evidence, for search for evidence of the other party's negligence. In many cases, our investigation will require and we send to the trucking company as violation letter. The trucking company holds so much of the documentation we need to build your case and may destroy or lose that evidence via letter of supplications required to preserve the document in question. Elements of negligence in a truck accident case. Every driver has a duty of act with reasonable care while navigating the road. Any evidence that suggests otherwise could mean they were negligent. Most of the driver-related causes of trucking accidents lead to a finding of negligence. Causes involving road conditions and equipment or parts failure will likely results in another party being found negligent. This could be something like the city not filling in potholes in the road or an electrical failure in the truck. Our truck accidents attorney will apply the four elements of negligence to the liable party in order to legally demonstrate your entitlement to fair compensations. We will work to show that the driver or other at fault party had a duty to act with care or safety. They failed to live up to that duty. Their actions led to the collision. You suffered injuries or damage. If the driver's actions violated the law, they could be found automatically negligent or negligent per CI violations of the law or statute. In the latter case, there would be no need to prove any of the elements of negligence except that you suffered injuries due to their violation of law. Click to contact our Houston personal injury lawyers today, who is responsible for a commercial truck accident. Like other commercial vehicle and ride share accidents, truck accidents are inherently complicated. One or more of several parties can potentially be held liable for the accident, including the truck driver, the truck manufacturer, the driver's employer, or the company who owns or loaded the cargo. For example, truck driving companies can be held responsible if they did not provide proper training to the individual operating the commercial truck or 18-wheeler. Facing a shortage of truck drivers, companies are highly susceptible to hiring individuals who are not properly qualified to operate a large 80,000 pound vehicle. If companies did not adhere to important safety provisions when hiring and training truck drivers, they can face significant liability. Trucking companies can also be variously liable. This means that they are responsible for any actions their employees take within the scope of their employment. If a truck driver violates HOS regulations, falls asleep behind the wheel, and causes an accident, their employer can share liberty. Multiple parties can share liberty. Several states and federal laws can impact a case which parties can be held liable. For instance, Texas properties responsibility law found in Chapter 33 of the Texas Civil Practice and Remedies Code factors into the equation. This law allows multiple parties to share fault and liberty for an accident. You can be partly responsibly and still recover compensation. It also states that a plaintiff may shares partial responsibility but still recover a portion of their damages so long as their portion of responsibility does not exceed 50%. Multiple insurance policies can complicate matters. Insurance is another